Lordship, may I be permitted to mention for an extension of interim model, Lordship, expiring on 22nd of August, my lord. I have already intimated that other side, my lord.
Group 1.
Group 1, land matter, my lord.
May I permit to mention?
Tomorrow to mention.
Grateful.
May I permit to mention on restoration application or on modification?
Group 1 matter.
Group 8.
Group 8.
Yes.
Restoration.
Yes.
My lord, this is the group 1 land matter, and this is the long pending matter. Copy, other side copy had already been served. My lord, kindly take this matter.
Whether it is listed or not.
Not listed, my lord.
Okay. All pleadings complete.
Yes, my lord. Other side served, my lord.
What is the status of the case?
Actually, the matter was without prior confirmation. Matter was sent to the amicable settlement for, and that's why the matter is still pending, my lord.
Amicable settlement.
The court is sent to the my lord. I forget.
No, you don't know the matter?
I know actually this is the long pending matter. Actually, I have instructed to the.
I want to know what is the status of the matter. Whether the pleadings have completed or
Yes,
not.
my lord. Actually, the matter is in Lok Adalat now. Without permission, the matter is sent to
Without
the
permission, how the matter can be go to the Lok Adalat?
My lord,
Order is there. So what you want?
my lord, that time we are not present.
Who are you? You are for the petitioner.
Yes, my lord.
So how can you say that without permission of the petitioner, the matter was sent to the Lok Adalat?
My lord, actually that is the instruction. That's why I am can be.
There must have an order. Have you searched the order? What is the last order for sending Lok Adalat?
Yes, my lord. I have served.
You search the order and mention it one day.
My lord, may I be permitted to mention one recalling application in connection with the criminal revisional application which your lordship had taken up during the vacation bench, my lord, without service of notice upon the opposite party / wife, my lord,
You are appearing?
on behalf of the wife, my lord. No, this is a copy of the audio. Your lordship wanted to see this one. On the very next page, my lord, your lordship find the relevant para 4. The quantum of pension had been quantum of maintenance had been reduced, my lord. She has to maintain 2 daughters.
Have you served?
My lord, we have not served yet, my lord.
Then why not serve?
Right.
Before mentioning, you have to serve.
But serve notice upon the other side.
Before mentioning, you have to serve.
Lord, if your lordship kindly allows the mentioning, my lord, I shall serve notice today, my lord.
No.
I shall serve a copy
To
of.
know the procedure before mentioning, there must be a service. Without service, I shall not take any mentioning.
Your lordship, item number 40.
You serve and come Monday.
Item number 40 of today's list. This matter is regarding to non-prosecution. Later is with me. If your lordship kindly take it.
To be mentioned matter 40.
40. The instruction of my client is with me right now.
Just edit it.
As,
Let me run the list. Thereafter, I'll take.
as your lordship. Great.
Yes.
May your lordships kindly, my lord, to mention, my lord, item number 136 of your lordship's list today, my lord. My lord, this I'm mentioning for withdrawal, my lord. There are certain mistakes in the writ petition, my lord, needs to be withdrawn so that it can be refiled by rectifying those mistakes, my lord. Item number 136.
And what is your application? What is your number?
So 40 perhaps.
Your number?
40, item number 40, my lord.
Item number 40 and until number
136.
136. Good evening. Tomorrow to mention. First matter.
As your lordship. Good. And my lord, may I also mention, my lord, you, my lord, 2024 notification matters, my lord. If it could be taken up, my lord, on Monday, because 26th, your lordship, my lord, would hear the other applications, my lord, the other writ petitions.
Monday is the 25.
Monday?
Monday is the date 25, is it?
25. So if these,
They fix the other matter.
yes, yes. So my lord, at least my lord, before 26, there would be an order, my lord, for them to file the report, my lord. That is where.
Within 1 day, how they can file?
No, no, they will not file, but at least there would be an
So,
order.
what
so
are
that
the
on 20
numbers?
4
Listed?
listed, all listed,
All listed matters?
all listed, all listed under
One.
group 8, and it will take some time, my lord, to reach. So item number 146,
These are under the
134.
heading group 1 matter,
Eight.
under heading,
group 8.
they are under heading mention matter.
No, 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 my lord. I want
New
them to
motion
appear.
matter.
Yes, new motion, my lord.
New motion matter I will take up on Monday. No issue.
No, my lord, the only issue is, my lord, these are item numbers 144, 146. So, my lord, perhaps, my lord, lordship might not. So, if it comes under mention matters, so even if it's not taken on 25th, on 26th, my lord, same order can be passed in respect of all the notification matters.
Then come on Monday then. I will pass the order.
Monday.
Monday. Next. Call the list.
Would like deep look.
One. I am for the petitioner, your lordship. Interim order is going to expire on 22nd of August, this Friday. And the division bench extended the interim order till November 30th.
In the
2025.
meanwhile, your lordship, there is a direction to file affidavit by the state.
Affidavit ready?
We need just a week's time.
Interim order.
You are the opposite party. Private opposite party.
ওই তো ওইখানে
হ্যাঁ,
এখানে
They
বলি
are the added party. Added
Have you served?
No.
So state required time.
I am late by
How
Mr.
many-
Serve to the state as
You serve a copy.
Reported
the state.
opposition.
He is
Of
the
state.
state. Mr. ধারা কবে থেকে ও স্টেট হয়ে গেল?
Opposition copy দিল ধরা। Private is from
Yes, even I will be praying that.
that key.
What you want, I can.
Yes.
Yes.
Yes, yes.
But that writ petition has been filed behind our back without making us party. That is also in appeal. No, I am opposing to that. And by suppressing the same, they had obtained the order. My order has been interfered with. They have not made me party.
Now, when the state would be ready to file affidavit?
next week.
Next week.
Next week. Affidavit in opposition on behalf of the respondent number 6 be taken on record. Copy served. State seeks accommodation for 1 week to file affidavit in opposition. Let the matter appear in the list on September 3,
Argument কে করো কেন? Panel থেকে
2025
একবার হয়েছে।
under the same heading. The state is directed to file the affidavit in opposition within the adjourned date.
The interim order be extended.
Interim order is there.
Short
There is an interim order.
2026.
Do you want to use any exception to the reply to the affidavit?
Yes, I have to. If the state file the opposition, I have to file an reply.
He has also.
Please.
So for private respondent, I will file my reply.
Okay.
I will paying for 2 weeks time.
The division bench extended the interim order till 30th of November.
Till
30th of November.
30th of November.
Hearing is going.
Kindly hears us, lordship. After that, lordship will decide.
এটা আলাদা মামলা। A different issue.
30th of that is the Sitara Begum.
Yes, ma'am.
No, Sitara Begum. This is a different issue. What I'm on.
কি বললাম বলো? The petitioner is agreed to use reply against the affidavit in opposition filed by the respondent number 6 within the adjourned date. Interim order passed by this court is further extended till 17th of September 2025 or until further order, whichever is earlier.
3 তারিখে লাস্ট করব।
17. Lordship, date has been fixed.
On 9th September.
So in any case, that is.
17th.
17 1 7
In that, in any way.
Seventh.
No. In any case, it is 17.
Call the list.
800.
My lord, this is a very short matter, my lord. But my lord, the situation is very helpless condition, my lord. I have filed this report, and this is, my lord, at the outset, I am not saying that I am not praying for any correction of the review, my lord. What happened in this matter, my lord?
Have you served? Who is the opposite party?
My lord, Mrs.
Even the
Suchor-
Assurance Company.
Mrs. Sucharita Pal has been, she is on appearing. I have been in constant touch with her. Since yesterday, day before yesterday, I had a talk. I understand that since she is very regular before the court, my lord, I think she might have some difficulty, my lord. Either, my lord.
What is the matter? Why you file the review?
My lord, the review is that, my lord, your lordship has been pleased to remand the order. My lord, kindly take my can too. I take just 3 to 4 minutes of your lordship's, my lord. My lord, kindly can 2 of your lordships, my lord. The matter was remanded by your lordship for production of a policy.
Very good.
And the impugned order was set aside on the ground that impugned order was passed under section 163A, but amendment was already allowed and amended plaint was filed. That's why the impugned order also set aside. Now, after the passing of judgment of your lordship, and before the matter was taken up on remand, the one disability certificate has been issued in favor of the claimant, victim. Now, the claim we approached the learned tribunal first. The learned tribunal has it has expressed its inability at page 17, my lord, at page 17 and page 31 to take the disability certificate on record on the ground that the remand is limited. That's why I want to place that disability certificate before the learned tribunal. But since there is an time limit framed by this honorable court, the learned tribunal had fixed the matter for the last chance, my lord. This is my difficulty.
In this matter, item number.
Lordship,
Lordship, in this matter, Miss Sucharita Paul is appearing on behalf of the respondent insurance company. My lord, she is engaged in courtroom number 33 before Lordship Anna Bandobadhyay. My lord will kindly keep this matter at 2 p.m. My lord.
page 31, my lord. I am not pressing, my lord. I am just as an outline, my lord. The second line, I have also filed certificate of disability. I have also the honorable court at page number 2, certified copy of the order dated. Considering the entire material, it appears to me that the appeal required to be remanded to the learned tribunal for the purpose of acceptance of the additional evidence as enumerated in Can 03 of 2029. That was policy. Now, therefore, in my humble estimation, the other documents excepting the insurance policy therein cannot be accepted in evidence. So I cannot say that he is incorrect.
This is the order passed by the court.
My lord,
What are you reading?
this is the order passed by the learned tribunal, my lord. It has expressed its inability because to be fair enough, my lord, I must be candid that this order is not incorrect.
No. There is you have not read the order entirely.
Kindly.
You read the order of remand. Last para of inner page number 2. Last paragraph of inner page number 2.
The learned tribunal shall allow claimant to adduce additional evidence, both oral and documentary, as
they desire and shall allow the insurance company to produce any witness according to
as to their wish after receiving such evidence according to law.
Yes.
So that evidence is limited to Can 3. When
not limited.
My lord, then my lord, kindly explain, my lord, it will suffice.
Explain. My order itself. Order is itself explanatory.
But my lord,
I allow both the party to adduce their evidence as their wish.
As their wish, but it is limited considering the entire material is appears to me the instant appeal requires to be remanded to the learned tribunal for the purpose of acceptance of the additional evidence
Yes.
as enumerated
Purpose
in
is for
Can 3.
acceptance of the additional evidence. But I have remanded openly. You see the order? This is
My
the
lord-
open remand.
My lord, then my lord, this order is incorrect. The observation of the learned tribunal is incorrect then.
That is the other issue altogether.
So my lord, that needs to
I
be.
have remanded open. Open remand is there. I allow both the party to adduce their any evidence in your wish. I have remanded, that is the for the purpose of that the matter can be appear in the record. That is the policy.
That is the
Because
policy.
it's there. This is the very required document. So I remanded back. I also allow both the parties to adduce their evidence as their wish. That means open remand is there.
My lord, they are, my lord, but the learned tribunal is.
That is altogether separate issue. That is not the matter of review.
My lord, then my lord, to the liberty to assess the order of the saying that it is a open remand because the learned tribunal, because if I now file an appeal, the appeal court shall rely on this part, my lord, because it is on Can 3, my lord, it is, my lord. Then my lord, kindly give me liberty so that I can.
Is the policy, which is a very valuable document required to be determine the matter. That's why I remanded back. But not the specific remand. It is the open remand. You read the last paragraph. I allow both the parties to adduce their evidence. Otherwise, I shall not allow anyone. Only to take the evidence of in respect of Can 3 on. I allow the evidence to be adduced by the parties as their wish. And also allow insurance company to adduce further evidence, anything. So it is not limited.
But my lord, my lord, to be humble, in my humble estimation, my lord, since if it is read as conjointly, my lord, it appears that they might have failed to appreciate, my lord. But my lord, kindly clarify that it is an
No,
open.
not clarification.
My lord,
No clarification.
because my lord, my lord, because otherwise I shall be remedialess, my lord. And this document has been subsequently. This document was obtained. This document came after the judgment came, my lord. So there is no other way, my lord.
You failed to apprise the learned tribunal and now appearing before this court to explanation of my order. How can it be?
My lord, we have, my lord, they have it has interpreted
So
in
what can I do?
my lord, then my lord, kindly give me liberty to challenge that order, my lord. Kindly give me liberty to challenge that order, my lord. Otherwise, my lord, the appeal will it can be infected. So I shall try my luck before the appeal court, my lord.
It is very much clear. You read that. This is the order of
We
remand.
tried
That is
to, my lord.
that is the purpose of the remand, and that is the order of remand. The last paragraph. There may be set a certain purpose of passing an order, but what is the order of remand? You see the order of remand. Purpose of passing an order may be noted anywhere of the order, but what is the operative portion of the order? You could not apprise the
My
learned.
lord, my lord, we have, my lord, but I myself appeared, my lord.
How can this court? How can this court? This court shall explain its own order.
Not explain, my lord. Then, my lord, give me liberty to, because otherwise I at present I shall be remedialess, my lord. The only 38%
That is
was.
Miss Paul.
My lord, Miss Paul is engaged in court number 33. My lord will kindly allow a short passover, my lord.
Pass over today. I have only first up today, you know.
Lordship will kindly allow a short
Then
passover.
come on Monday.
Monday, my lord. Monday,
Under the same heading.
under the same heading.
Grateful, my
In
lord.
presence of Miss Paul, I shall pass the order.
Deeply blessed.
Next.
I, my lord, I'm preparing for the state respondent.
And here for the petitioner, my
But
lord.
not a single card has
Yesterday,
been
my lord,
rejected
Mr.
for us.
Chatterjee had served a report upon us, my lord. And my lord, I've gone through the report, my lord. The report very clearly says that, my lord, not a single card would
card
be
has been
delayed from
deactivated
the,
from us.
my lord, the units of the petitioner.
Petitioner's one.
And it's on affidavit, so I have, my lord, no reason to disbelieve that. So Lordship may dispose of, my lord, the writ petition in view of the report and, my lord, the categoric assertion in it.
In which paragraph you have said, Mr. Chatterjee? Page 9, my lord. My lord, page 9. Now the respondent authority is going to fill up the new proposed FPS with the number of 2156 digital lesson. 9. Page 9, my lord. Paragraph 9. Page 9, my lord. Page 9. Page 9. Paragraph 10, my lord. Paragraph 10. Where is your page 9? New proposed.
It is better. It is
Page
better.
8. Yes.
It is better if your lordship comes to page 7. Page 7, my lord. It's a long paragraph on starting.
2156 beneficiaries tagged with Mohammed Abdul
7 if your
Rajak.
lordship sees, page 7 if your lordship sees, my lord. In the middle, my lord, it is specifically mentioned herein that not a single digital ration card will be deducted from the petitioner's FPS for the said vacancy memo number so and so. Neither petitioner would be affected by the proposed vacancy at the central location, nor his volume of business would be reduced considerably. So this, my lord,
And that will be marked, my lord, in the box, my lord. Respondent authority is going to fill up the new proposed
lordship has seen that at
vacancies.
page 7.
2156 essence cards in
And
pooling
my
by
lord, this is on
2156.
affidavit. So I have, as I said, my lord, I have no reasons to dispute.
2156 are pooling from the, my lord, Mohammed Abdul Rajak. Okay. Please take down. Petitioner is running a fair price shop at village Bausi, Bausi, PO Upper Fatehpur, Block Lalgola, District Murshidabad. Having lawful possession of godown space at plot number 538 under Mauja Uparohar, UPAROHAR. Full stop. The petitioner filed this writ petition challenging a vacancy notification dated 5th November 2024 issued by the concerned subdivision controller food and supply. It is the contention of the petitioner that by the said notification, the DRC population of the petitioner FPS would be curtailed. By such, he would suffer financial loss. After the instant writ petition be filed, this court has directed the state authority to submit a report. Respondent number 1 to 4 submitted a report affirmed on 31st day of July 2025. It appears from the said report in paragraph 7, paragraph 9, page 7, that within quote, it is specifically mentioned herein that not a single digital ration card will be deducted from petitioner's FPS for the said vacancy memo number 1064/SCL/MSD/24 dated 5/11/2024. Vacancy ID number 202300222901, comma. Neither petitioner would be affected by the proposed FPS vacancy at the central location Lalgola, Durgapur, College Pada, within bracket Lalgola College, nor his volume of business would be reduced considerably. And that was fooling from Mohammed Abdul Rajak's full stop area, my lord. Mr. Amritalal Chatterjee, learned counsel, appearing on behalf of the respondent authority, submits that the new vacancy was declared and it will reduce It will reduce 2156 GRCs from Mohammed
Abdul Razzaq, my lord.
Abdul Razzaq,
License number WB033
within bracket, license number WB
WB0
0 triple three
33388
88
5182.
5182.
Grateful, my lord.
Bracket close.
It should be Mohammed
Having heard the
Abdul
learned
Razzaq.
having heard the learned counsel for the state respondent, also perusing the report filed on behalf of the state respondent, it appears that the petitioner's FPS shall not be affected by the impugned vacancy notification. Thus, I find nothing more to elaborate the instant, nothing more to proceed with this instant writ petition. Under the observation, the instant writ petition is disposed of, taking note of the affidavit in report in the form of affidavit filed on behalf of the respondent authority. Disposed of.
Grateful, my lord.
But the only thing, my lord, the name is not Abdul Razzaq, but it is Mohammed Abdul Razzaq.
নামটা লিখেছো?
MD Abdul Razzaq.
ABTUL.
ওটা মোহাম্মদ আব্দুর রাজ্জাক হবে। আব্দুল রাজ্জাক লেখা আছে প্যারাগ্রাফে, কিন্তু মোহাম্মদ আব্দুর রাজ্জাক।
MD আব্দুর
রাজ্জাক।
DUR ঠিক আছে তো? তাই তো? জেড দেখে
Meaning is same, Abdul or Abdul.
Yes.
Grateful, my lord.
Next. Not today. Next.
Item number 8, Mrs. Park.
Now you are appearing.
I'm sorry, my lord. I was appearing before on.
I fixed it on Monday.
I'm extremely sorry.
Monday.
My lord will pardon me. I could not.
No, the issue is that I have passed the open remand and they are saying that no, this is not open.
Only because of that first paragraph of.
This is the purpose of remand.
Yes.
But the order of remand is operative portion is very clear.
Yes, it is there.
Open remand, I allowed the petitioner, also the insurance company, to adduce their entire evidence, whatever they wish. That means the entire floodgate is open.
My lord, they are not, we submitted the thing.
Failed to apprise the learned tribunal and appearing before this court.
My lord, now, my lord, we are remedialist. My lord, kindly give us liberty
I
to
shall
assess
dispose
the-
of the review application by stating entire thing, no issue. Okay, come on Monday.
Same.
Great.
Next.
Well, Mr. I am for the petition.
Lordship, I am appearing for the state respondent.
It's better after complying all the formalities have been collected and approved, but we just issue offer letter and license without showing anything. So kindly come to stay to page 29.
Where is your offer letter? Approved.
Page 29.
Yes.
Lordship, may I place the report, Lordship?
Yes. You serve a copy of the report.
আমি একটা আপনাকে পরে জেরক্স করে দিচ্ছি, কপি নেই। একটু দেখে নিন তো দুটো ছোট আছে কিনা, দেখে কপি নাই। তাই আমি আপনাকে পরে জেরক্স করে দিয়ে দিচ্ছি, কপি নাই আর।
So there is an interim order.
Last time has submitted, she has submitted this report.
Yes.
Lordship, the
But
thing
In the
actually,
year 2025, same person also filed a declaration. Not to with a prayer or not to retire. There is also an order. My lord passed on. Who has filed this petition?
Alok Adhikari.
Yes, which is annexed with the petition.
That is the writ petition number 26671.
And now this is petition number 9168 of 2025. Order passed on 23rd June 2020.
You file exception if you want to file. It would be better. Please take down report in the report file on behalf of the state
আমি দিয়ে দিচ্ছি দিয়ে দিচ্ছি।
authority. State respondent be taken on record. Copy served.
Lordship, lordship,
Copy served.
আমি দিয়ে দিচ্ছি।
The
Just দেখেন।
petitioner is a leave to file reply stroke exception if any against the report within 1 week. Within a week. List the matter on 8th of September.
8th of September.
Under the same heading. Next.
হ্যাঁ রাখো আমি
Attorney Miller, I am for the petition.
Millard,
Yes,
Millard, kindly takes it up Monday, Millard.
Monday.
I have some difficulty, but kindly takes it up Monday. The report is supposed to get the signature in the person.
Report I want.
Yeah, I know.
Okay, not this week. Next.
Lord, in this way, I appear for the petitioner, my lord. The case is, my lord, petitioner's case.
And on the last occasion, your losses is pleased to direct me. Your losses kindly sees the last order.
Is there any possibility to
So far as the blacklisting order is concerned,
Yes.
I have, because my report is with the oath commissioner, it has been affirmed. Because the losses directed me to file a report
Yes.
with any provision.
Is there any scope,
Yes, there is a provision of appeal against the
against
blacklisting
order
order.
of blacklisting?
Yes.
You file the report. Come on Monday.
It's also kindly take it about 2 p.m. Or I will
2 p.m. I have other determinations.
a short password because it is already with the oath commissioner. I will just come on.
If it is ready, you serve a copy to them. It will appear on Monday. I will pass the order on Monday. You serve a copy to them.
My lord.
Not this week.
My lord, I'm appearing for the state. There was on the last occasion, there was a direction for affidavit, my lord. Our instructions have come in late, my lord. I am praying for 3 weeks.
No,
my
I am objected.
Coming late.
No, you will also given time to file opposition 4 weeks.
my lord,
What happened, my lord?
sir could not arrange it, my lord.
State did not file any affidavit. He knows. He state file affidavit matter may be directed your lawsuit to execute the agreement. But what happened, my lord? His state did not file any affidavit. But in the minute before filing affidavit, on the quota for October and November has been issued. Intentionally. Now you are also directed to file affidavit or within 4 weeks.
Yes, very short affidavit. Why you allow other persons to run?
Only one paragraph should be dealt with. Only one paragraph.
Yes. What is your submission?
My lord, sometime.
How many time? I have passed the
As per my lord, pleases my lord, at least 2 weeks, if not at least 2 weeks, my lord. Please, my lord.
Very well. You come within 3rd of September. Okay.
My lord.
3rd of September.
My
I
lord,
have
my
given you 10 days.
My lord.
3rd of September is the date. Wednesday.
Then directed
Last time.
last time. Directed preliminary.
Yes.
No.
And accommodation is sought for on behalf of the state respondent to file affidavit. Strong objection raised by learned counsel for the petitioner. It appears that while this court passed order on 16th of July 2025 has made it clear on which grounds the affidavit shall be placed. Full stop. The state submits their inability to file affidavit, considering the nature and circumstances of this matter, and also considering the urgency as argued by the learned counsel for the petitioner. I allow the state respondent to file affidavit within 10 days. Let the matter appear in the list on 3rd of September 2025, peremptorily, for hearing of this matter. The state is directed to submit their affidavit within the submit the affidavit within the date fixed by placing an advance copy, by serving an advance copy to the learned counsel for the petition.
Let's see, one request, can I make my on university fix the matter on 3rd September. Mr. Bandyopadhyay request can be taken up at 10:30 on 3rd.
10:30 the matter cannot be. It is under the heading mention matter. I will take up the mention matter then. This is the first matter it would be, I think.
If your lordship on that day if your lordship fix any matter on 3rd September 10:30, then this matter cannot be taken.
No, 10:30 I have not fixed any matter.
Now there is a time, my lord, fixing the matter on 3rd on 10:30.
I stop myself to fixing the matter 10:30
because
Mr. Mukherjee, who is appearing online.
I am not on this statement about the Mr. Mukherjee. Whatever I learn, Mr. Mukherjee, Mr. Agarwal. I am not
in case of Mr. Mukherjee, I fix the matter 10:30. Otherwise, I not fix any matter on 10:30.
No, some matter will also fixed on 10:30.
No. I have already stopped every matter. I am not fixing any matter. 12:30 or 2. What you want?
2 p.m. on 3rd. Because when I want to do the matter on that day,
I know that.
Because when if that day matter cannot be taken up, I lose the quota for the October.
Wednesday, there are 3 2 p.m. matters. Already fixed.
12:30,
not 12. 12:30 I can fix. If I fix 12:30, it will be difficult to take up. Very well, I can fix it. Hey, take it out. I can fix it on 12:30. That is
তারিখে 12:30 ফিক্স করেছি। আমি কোনোদিন বলি না এই ম্যাটারটা আমি ছাড়বো না।
12:30 কিছু আছে? 12:30 at 12:30. Yes. Next.
Madam, for the petition. On the last occasion, your lordship directed served copy, my lord, I have served copy. On that day, nobody appeared. Even if today is also nobody appeared. This is for the updating of the FPS profile, nothing else. But I am this is the cooperative, you know, the 3 partners are there, partnership firm. One partner resigned. But I have taken another partner, his daughter-in-law. But it was firm has already been accepted and 3 partner has already been regularized. But I filed an application for updating the FPS profile. But that was rejected by them on the ground that the partner which has been included on page 5 of my supplementary affidavit. Page 5. They have no such power. When the firm has already been accepted my proposal, and I also given them They have said partnership deed is not a register before the competent authority. That is wrong. Now, this is a registered partnership firm. I have annexed it. And also, he is not a family member of the deceased. 2 points has taken. My lord, I can show page 61 of my writ petition. Your lordship will find the additional register of firm has already been accepted. Dipal Chandra Rai retired on 2/2/15 and Rekha Rai joined on 9/2/15. Page 61.
So who are the partners initially?
Well, 3 partners. One partner is resigned, and we have
Partner resigned.
resigned.
What was his name?
Well, 61, page 61, your lordship will find.
Page 61.
Yes. The remark column. The remark column. Dipal Chandra Rai retired on 2nd February 15th. Rekha Rai joined on 9 February 15th. And that was accepted by the Register of Fund and Society, Non-Trading Corporation, West Bengal. It was accepted by the Register of Fund. They cannot say that the deed is not registered, he is not a deed. Your lordship will find deed is page 28. This is the registered deed, Register of Fund. They have no such capacity to take this point, as he has no power to do so. Page 37, you have also seen.
Page 37.
Page 37.
Page 37.
Licensee name
Page 37 of writ
of my writ petition. Yes, my lord. Licensee name, Mr. Rai brothers, Joypal Rai, Anita Rai, 3D, dead. They have said.
3D means?
Didn't mean dead.
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 Who died?
Nobody died. One resigned, and his daughter-in-law has already been accepted as a partner of this firm. That was accepted by the Register of Firm. Therefore, they cannot say, for this reason, they cannot update my profile.
Where is your application before the authority?
That is online application they have filed. Page 22. Additional Register of Association. None.
Your prayer was conversion from sub-center into permanent.
That is other case. That case is also here. Well, I have annexed this. Also that is also pending before your lordships for sub-center to a converted. This is the main center. This is the main center. That was one of the claim that is also pending before your lordships.
No, where is your application?
Right.
Have you filed it? You have not filed it.
My lord, I could not
You filed it.
annex this.
You annex this.
I could not annex.
Come on next week. Not this week. Next.
But I am appearing for the private respondent, man. I am appearing for the petitioner.
I am appearing for the state, my lord. I am led by Mr. Papan Dottu. I am saying it.
When a vacancy has been notified for appointment of fair price shop dealer in the subdivision Lalgola in the district of Murshidabad. If you should kindly turn to page 28.
Yes.
Page 20 is the vacancy declared notice notified on 16th May 2024. Kindly turn the page. Yes. Time and again, place before lordship within once again I am placing part 2 eligibility criteria box panchayat area. Requirement of size of godown and shop room.
Yes.
300 square foot along with 100 square foot adjacent roof and the shed. Then kindly come to part 3. Following person entity shall not be eligible to apply for a license of fair price shop dealership, namely. Kindly turn the page. The second paragraph. The person holding, have you also got page 30.
Yes.
The person holding a post in the establishment of any state government or central government or any authority or institution or local self-government established or constituted by the under the constitution or by any other law made by the parliament or a state. Well, can I take note of? By or under the constitution or by any other law made by the parliament or the state legislature or by notification issued or ordered may be by the central government or a state government. By notification, if any vacancy is notified, in that case, either state government or central government, person concerned will not be allowed. Now, kindly come to my lord. See from bottom for leased rented property. Have you also got my lord?
Yes.
Registered, notarized, lease deed or tenancy agreement for at least 4 years with copies of rent receipts for all the months from the date of agreement till date of application and registered deed oblique ROR. Kindly take note of my lord. Either deed or record of right in the name of the land owner or lessor. Registered deed or record of right. Then kindly turn to my lord page 32. I have applied for the acknowledgement has been issued. My application was within time 4th September 2024. Page 32. Then page 35, if you will kindly turn up my qualification. Obtained the degree of Bachelor of Arts University in the year 2008, fulfillment present requirement. Second class with honors. Qualification. Highest qualification is required to be placed. The next page, my lord, kindly see the bank balance. Page 40, your lordship, kindly turn up. My date of application is 4th September. Kindly see page 40 after 3-4 lines. Page 40, there are some transactions. 4 columns are there. 1,19,000, 1,16,000. The lowest was 1,16,000. Requirement is 50,000. Now, your lordship, kindly come to page 43. The sketch map I have given, where from it appear, my lord, the right hand side box, fair price shop go down 595.32 square feet, office room 197, requirement 100, tin shed 149, totaling my lord 793.17. I have calculated it. Plus 149. The shop come go down, mixed my lord 793.7, then tin shed 149. Now kindly turn the page, next page. The date is important, my lord. Kindly see, my land has been converted on 30th December 2024 from house to VT. 30th December. Lord, kindly come to page 46, the inquiry report, which I have discussed, that has also been accepted by the inquiring personnel. kindly read my lord. 2-3 paragraph I shall read my lord. Whether second B, whether shop come go down is fully constructed, yes. C, total number of compartment room for so and so feet. Then my lord, dimension of the go down shop room has been given. It comes around my lord 381 and 158. 34 into 11 comes my lord 381. 13 into 12 comes my lord 151. Totaling 540. And the shade is 153. Then my lord, kindly come to K. Status of the floor of the godown, cemented, distance between the office shop and godown adjacent, whether the land for so and so rented, character of the land Bastu. Status panel so and so, account and balance have been submitted. Everything is there, OBC category. Approach road 10 feet, everything is there. Then kindly turn the page, my lord. Report has been submitted. But kindly read my lord, page 47. Report to Officer Jhagan Swansho. He is a civic volunteer, private respondent. My learned senior is appearing, Mr. Agarwal. He is a civic volunteer. If you want to kindly see, report to the OC Jhagan Swansho. There is no dispute possibly also. My lord, kindly see the serial number 42. Then kindly turn the page, serial number 42. The duty has been shown from bottom, my lord, 13 lines. PS main gate, Shrenti CV 42. From bottom, 9th line, 13th line. Oh, thank you. Kindly see that date 30th December, top right hand side, left hand side, 30th December 2024. Then I have been called for, my lord, by the additional district magistrate before the district level fair price shop selection committee, which will appear from page 49. The date of hearing was fixed on 11th of July 2025 at page 49. I participated and produced all the required documents. The civic volunteer certificate I have also annexed. So far the private respondent is concerned, page 50. I lodged a complaint with the principal secretary with copy to the deputy director, district controller, subdivisional controller, bottom portion. So far the status of the private respondent is concerned, he is a civic volunteer.
Yes.
Kindly come to paragraph 20. Paragraph 17, 18 and 20, 3 paragraphs. Page 8 of my petition. 17, I am reading, my lord. Your states that during the course of interview, the additional district magistrate general intimated your petitioner that your petitioner's candidature cannot be considered as an eligible candidate since on the date of application for grant of fair shop license against the subject vacancy, the land was not classified as costly or commercial or token and selected the candidate of private respondent number 3. Though the fact is that the private respondent number 6 is not an eligible candidate, since he has engaged himself as a civic volunteer, which is classified as government job, and in terms of the vacancy clarification notice, vacancy declaration notice, dated so and so, a person working in a government job has been favored to submit application against the subject vacancy. The petitioner states that though the additional district magistrate in an arbitrary, unfair, unjust, and discriminatory manner rejected the candidature of the petitioner and selected the private respondent 6 hearing for grant of fair shop license, despite the fact that the private respondent number 6 hearing is engaged himself in a government job and affirm false affidavit entirely stating therein that he is an unemployed, which is nothing but a glaring instance of federalism administrative high page, which clearly violates Article 14, 91G and 21 of the Constitution. So, my lord, I have shown to your lordship so far the classification of land is concerned. If your lordship once again come to page 44, the date of change of status of the land, character of the land, 30th December 2024. And the next page, Kindly come to page 46. From top, my lord, third line, date of inquiry, 31st December 2024. I will also got my lord, page 46.
Yes.
And the land classified as my lord VT on 30th December. So, my lord, on the date of inquiry, land has duly been changed the character from house to VT. I have also shown to your lordship that requirement is, my lord, either leased it or, my lord, R1. Your lordship, kindly take up the books, old books, from C at page 1.46.
বইটা কোথায় গেল আমার? সে বইটা নিয়ে গেল টাইপ করতে, নিয়ে এসছি।
I am handing over. I'm handing over. .46 page. Application for issue. Have you also got? Kindly come to page 148. 1.48.
1.48
Yes.
Form C.
Form C, 32 serial number.
Yes.
It says, my lord, character of the land of the premises pass through commercial, agricultural, etc. The 3 points so far my rejection is concerned, my lord. The application notification says, my lord, either ROR or lease deed registered. On the date of inquiry, it has really been converted. The prescription says, my lord, statute says it may be vastu, commercial, agricultural, etc. My land was from the very date of submission of application was out. So I also fulfill the condition.
Yes.
But I have shown to your lordship. Your lordship has already considered these aspects of the matter also. Kindly take note of. Your lordship is not settled principle of law. একটা দিচ্ছি জাজমেন্ট নয় কোথায় even if you lordship kindly come to the first there is the pagination third page column number 30 even my lord there is no scope for cancellation kindly turn my lord classification of land or proposed shopcom go down at the bottom last table A, B, A got smaller Dokan 5 marks, Bastu, Vita, Homestead 3. Classification which are convertible to Dokan go down under land solar 1. So when there is no scope for cancellation. I may be given my lesser marks, but for the part, for the consideration that on the date of making submission of application, my land was out. I cannot be debarred. There is no scope for cancellation. I have shown to your lordship, even on the date of inquiry, it has duly been converted. I have also shown to your lordship from the statutory provision that it can be also agricultural land. My land was out on the date of application. Even my lord, I am submitting before lordship, even on the date of inquiry or hearing date, if it is classified as my lord, which land can be converted, 1 marks. And according to my understanding, my lord, this is a clarificatory circular. It should be given effect retrospectively because it has been published on 21st of March 2025, that is after inquiry. But my submission is that, my lord, since it is clarificatory, it should be given effect retrospectively. I have got one judgment also, my lord, that if any circular is beneficiary, that should also be given effect retrospectively. This is a beneficiary circular. And so far, my lord, civic volunteer is concerned, I have shown to your lordship. এটা আমার খারাপ কপি আছে আচ্ছা একটা করে দেবো দুদিন আমরা দুদিনের দিন একটা বড় হ্যাঁ কন্ডিশন থাকে যে সাপোর্ট করবে না তাহলে দুটো দেবো বাট কোন জায়গায় বলছি Well, kindly come to page 9, petition, paragraph 18. Just for a moment.
Page
9, paragraph 18 of my petition.
yes.
Paragraph 18, I am reading page 9. Your petition states that though the additional district magistrate in an arbitrary and unfair kindly come to my lord once again the notification. So far the civic volunteer is concerned, I have already read, but prior to placing before your lordship the circular, I am reading my lord last 2 lines, page 30, second paragraph, top, holding a post in the page my lord 30. Page 30. A person holding a post in the establishment of any state government or central government or any authority or institution of local self-government like Malad Panchayat municipality, established, constituted by order of the constitution or by any officer of law made by the parliament or state government or by notification. Kindly take note of, I am taking advantage of this. Issued or order made by the central government or state government, a notification. But I have just now placed before your lordship a notification dated 29th of October 2018, issued by the office of the Commissioner of Police, Kolkata. Department of Civic Volunteer. Kindly read, my lord. Kindly come to my lord. My lord, second page, middle portion, how to apply. And disciplinary matter. C. First, my lord, C, second paragraph. What is the duty and responsibility? Kindly see the duty of the civic volunteer. All civic volunteers will exhibit highest degree of discipline and devotion to government duty. Kindly take note of government duty. I am reading, my lord, from disciplinary matter C. And the duty has been assigned in C. Then kindly turn to my lord D. How to apply. That is also there. So I am emphasizing, my lord, that it is a government duty being discharged by the private respondent. In any manner, he cannot say that it cannot be suppression by reading in the application that I am unemployed. Paragraph 70. Paragraph 70 I have read. Then only judgment I shall place before lordship.
No, this notification is of Kolkata Police, not West Bengal Police.
Yes.
Lal
For civic volunteers.
No, for Kolkata Police civic volunteers.
It is not Kolkata Police, so far my learned client is concerned. But the duty and responsibility by specific submission, all civic volunteers are same.
No, Kolkata Police there may have some certain circular.
Let them show, my lord. Let them show. I have not, I could not collect, my lord, so far the
Police, there are certain other circulars.
but they are civic volunteers. I could not. But I got it, my lord, I am placing before it. But duty and responsibility of the civic volunteers. Possibly, my lord, there should not, may not be any change or difference. There is a circular, but we are not getting it. That is also, my lord, 7th of July 2007, which will appear from the first paragraph of the notification, last line. That we could not collect.
Yes.
Now, the judgment I shall rely upon your lordship. The stalwarts are against me. 2018, volume 13, Supreme Court case. 2018, volume 13, Supreme Court cases, page 239. This judgment says if any circular is beneficiary, then it should be given effect retrospectively. I have shown to your lordship that subsequently it has been changed and marks have been allotted even if it is agricultural land. And since it is a beneficiary circular, it must be given effect retrospectively. 2018, volume 13, Supreme Court cases, page 239, paragraph 25. calculated. Well, that is possibly, my lord, but my learned friends will not oppose this. Logic is
Principle is well known. But the applicability is
not question. And my judgment, my lord, my book bag is just rushing. 2020 volume 3 Supreme Court cases, page 59. Same principle, my lord, retrospective and prospective. But these are my submissions, my lord. As of now, my lord, license has not been granted to the private respondent, but he has been selected, as I understood. But state can clarify the position. So I am praying for an order of status quo as on today and fix the matter by directing the state to submit a report, whether what I am placing before lordship is correct or not, and what marks has been awarded to my client and to the client of my learned senior friend, Mr. Agarwal. In the meantime, status quo may be passed. Let them submit their report.
My lord, I am appealing for the prior respondent, my lord.
yes.
My lord will kindly come to the writ
He
petition.
needs to address the lordship first. So my lord, let him argue first. Yes.
My lord, kindly come to page 4, paragraph 5. Paragraph 4, my lord, kindly. My lord knows that once vacancy notice is issued, then inquiry is held, then thereafter appearance before the selection committee, then approval. Now, my lord, kindly see, in paragraph 4, vacancy has been given. Publication made on 16 May 2024. Then paragraph 5. Your petitioner, you are having all eligibility criteria, made application on 4th September 2024. Your lordship will kindly mark the date. Application is made on 4th September 2024. Then, my lord, kindly come to page paragraph 7, next page.
Judgment books have come. May I just place that type of bullet?
Retrospective to. কে বলছে তো কেউ ডিনাই করছে?
They are not denying so far the logic of the.
Then, my lord, kindly come to paragraph 7. Rather, some other candidates having also applied for the said notification, including prior respondent. That is myself, my lord. Now, paragraph 8. Your petitioner states that immediately after submission for grant of APS license against the said vacancy on 22nd October 2024. Your lordship kindly mark the application has been made on 4th September 2024 and application for conversion of land has been made on 22nd October 2024. That is after making application. Paragraph 5, application made on 4th September 2024 and application for conversion of land is made on 22nd October 2024.
Yes.
My lord knows, my lord, in paragraph 19, my learned friend had shown the old book. But my lord, there was an amendment that if the land is of other character, the application needs to submit application for conversion on or before the date of application for APS license. So it has not been done. So there is a violation of paragraph 19 of the vacancy of the application form, which is statutory form. One, my lord. So therefore, he is not eligible for being selected. Now, my lord, kindly come to paragraph 9. Your petitioner states that after being selected as an eligible candidate, he says that he has already been selected and thereafter inquiry has been held. Against the said vacancy notice dated, your petitioner received an inquiry notice. If he has been selected before inquiry, I have never seen, my lord, that after being selected, an inquiry notice is given and in selection is made before inquiry. Then, my lord, kindly come to page 12. My lord, page 7, paragraph 12. allegation is that I am a civic volunteer under Lalgola police station. I admit it. I am. But it cannot be said to be a post under state government, my lord. On this count, my lord, this honorable court has already passed a judgment. I am relying on that. It is known to my learned friend. I may give a copy to him. Coordinate bench. My lord, I kindly come to last page, your lordship. Last but one page, page 9. Taking into have your lordship got my lord?
Yes.
Taking into account the aforesaid constitutional provision and the scheme of Home Guards Act, Allahabad High Court had held that a home guard shall not be deemed to be a holder of a civic post. The position of a civic volunteer is more vulnerable than a home guard. There is no statutory recognition of the civic volunteers. They work on the basis of daily wage and under the scheme of no work and no pay. Therefore, they do not hold any civil post under the state government. In view of the above discussion, I have no other alternative but to hold that the respondent number 6 does not hold any post under the state government. Therefore, he is entitled to license of a fair price shop. And the decision does not suffer from any. The case was my similar case. There was the allegation against the respondent number 4 that he was a civic volunteer and a coordinate bench has already held that he does not want. And my learned friend has shown your lordship the notification that is of Calcutta police. Your lordship knows better than me, my lord. There are two separate regulations: police regulation of Bengal and police regulation of Calcutta. That are difference between them. Then, my lord, kindly come to page 8, paragraph 17, my lord. During the course of interview, the additional district magistrate intimated your petitioner that your petitioner candidature cannot be considered as an eligible candidate since on the date of application for grant of FPS license against the subject, the land was not classified as Vastu. Therefore, my lord, application was not made, application made later and conversion was allowed on 30 December 2024, just one day before the inquiry. But that cannot be, that is contrary to the statutory provision. Now, my lord, it is mere a statement. Selection board cannot say that you are will be granted license, you will not be granted license, he will be selected, he will not be selected. In my humble submission, my lord, it is a premature application. There is no order of rejection. When interview held, it goes to the director, then it goes for approval to the state government. There is no selection as on date, at least to my knowledge or to my client's knowledge, approval has not yet been given to any candidate. So until there is a rejection, my lord, merely by saying that at the time of process of the application that I have been rejected, my lord, I believe your lordship will agree, will appreciate. Kindly see the prayer, page 20. A writ of and or in the nature of mandamus, commanding the respondent, their main agents, subordinates, and assigns to rescind, cancel, and or withdraw the decision to reject the candidature of the petitioner for grant. Where is the rejection order, my lord? That will available in portal, but that has not yet been finalized. Dated 16 May 2025, that is vacancy notice dated, issued by the subdivision and subsequently selection. This selection has not yet been approved. It is going to my knowledge, because I have not yet been intimated that I have been selected. So what can your lordship, my lord, but subject to your lordship approval, my lord, what can this court do, my lord? Maximum that your lordship can direct the authorities to conclude the process within a particular time. And if someone is aggrieved with that order, then only the writ will lie. And my lord, state is appearing for lordship, my lord, they can well say whether that process has been. My lord, would your lordship kindly see this paragraph that 19. Yeah. That application is required to be made before the date of, for conversion to be made before the date of application for the. Please start. August 23. Amendment has been. Yes, my lord. One, my learned friend is not eligible as per criteria. Two, there is no rejection order till date. Three, my lord, civic volunteer does not fall within the appointment of the state government. These are my submissions.
May I please, your lordship?
Yes.
Now, my lord, the first submission is, my lord, this petition is premature. And my lord, this secondly, my lord,
No decision has yet been taken.
my lord, the recommendation has been made. I am not saying the selection or rejection is, but only that is my instruction. I can't go beyond that. Only recommendation in favor of the private respondent has been made, but that has not been approved. So there is no decision as indicated in the prayer part.
Is there any portal, anything like that?
No, not as yet.
Not
Now
yet.
this is the recommendation, my lord, if accepted by the competent authority, then it will be a decision.
Yes.
That stage has not come. So that's why I'm saying it's premature. Now, my lord, in all, there were 12 applicants. 3 were shortlisted. The writ petitioner and the private respondent, another person. Now, the private respondent has scored high, has secured highest mark. That's why he has been recommended for this license. Now, here, lordship, now when he applied, then he was working as civil volunteer, but before consideration of the application, he resigned. And my lord, so the resignation, when the applicant was considered, he was not in employment at all as civil volunteer. My lord, and this is also my submission that this is not a post as indicated in the advertisement at page 30. If your lordship kindly have a look to, it starts at page 29 of the advertisement, and the relevant portion is page 30, second paragraph. Person holding a post in the establishment of any state government, that is page 30 at the top. Lordship got it?
Yes.
Second. So he is not a holder of any post. He works on no work, no pay basis. It's not a civil post as held by the learned coordinate bench, honorable coordinate bench, in a judgment cited by Mr. Agarwal. So then lordship kindly sees so he's not holding a post, and in addition to that, he resigned. So on the date, so he was not, whether he was not in employment at all, I would say. He was not further to speak of holding any post in any government establishment or authority or institution or local self-government. So, and considering that he scored higher, he was recommended, but it is still awaiting approval by the competent authority. Now, my lord, this precisely, my lord, the recommendation has not been, my lord, approved by the competent authority till date. And, my lord, the writ petitioner was found not eligible because his land for conversion was yet to be made on the date of inspection, and he has relied on a government order dated 21st March 2025 in support of his case, and citing a decision of 2018 Supreme Court, the judgment, neither the judgment nor this government order dated 21st March is applicable in his case because of the last line of this government order. Last line is underlined. This order shall take effect from 1st of April 2025. So when the government order is specific about it, then the judgment of the Supreme Court will have no application. And this is always prospective in nature. The application that was considered, application he made on yes, 4th September. Yes, 4th September 20. This is long after that this order of government came. So this has no application, nor the judgment that has been cited by my learned friend. So, my lord, as on date, my lord, there is no scope for interference because there is no cause of action for the petitioner to come before your lordship. So, on this ground, my lord, I believe, my lord, your lordship may dismiss the writ petition. These are my submissions.
So for the first point which has been raised by Mr. Agoral, my learned senior friend.
Yes.
That I am not an eligible candidate. I am taking the submission, help of the submission of my another learned senior friend, Mr. Dotto, who initially subjected that a panel has been prepared. Out of 11 candidates?
No, I didn't say panel. I said 3 were shortlisted. That's the exact language I said.
3 shortlisted means out of 11, 3 is eligible. So question of I am not eligible does not even arise at all. I have been awarded marks by the inquiring team. Question of cancellation of my candidature at the threshold on the ground that on the date of application, my land was not converted to Bastu, Dokan or something else.
Now, whether decision has been taken that your candidature was rejected?
Recommendation has been made. Vice versa, my candidature has been rejected. My name has not been forwarded. It is a specific submission of the learned state advocate before your lordship that the name of the private respondent has been recommended by the district level sub-selection committee. Meaning thereby my candidature has been rejected. Whether they have uploaded it or not, it is immaterial. It is a specific case of the state. Out of 11, 3 has been shortlisted. So I am an eligible candidate. And out of 3, 1 name has been recommended. So my eligibility criteria has been taken note of, found I am eligible. Thereafter, marks have been awarded. I am not within the 7 whose candidature has been rejected at the threshold. Since I am an eligible candidate, marks have been awarded. Then a panel has 3 candidates have been prepared. Out of that, it was found another learned friend, Mr. Agarwal's candidate, got the higher marks. And his name has been recommended. My case is that my name should also have been recommended. Kindly consider the consideration. Now the candidature of my learned friend's client shall only be considered by the directorate level. Even if his candidature is cancelled, my candidature will not be considered. Because only 1 name has been forwarded. Out of 3 shortlisted, 1 has been forwarded. If he fails, then there will be a fresh vacancy. That is my cause of action. Unless there is a restriction, unless there is a protection given to me, even if my lord his candidature is rejected, there will be a fresh vacancy. Although I have become eligible candidate, 3 shortlisted panel, my candidature has not been forwarded to the directorate. They will not take note of my candidature. On that ground, while there is a scope to entertain this writ petition directing the state to submitted report in the meantime not to finalize the selection process. Then what is the second course of argument? My learned senior friend Mr. Dotto has argued that on the date of application, private respondent was civic volunteer. Kindly take note of. Subsequently, either on the inquiry or at the time of hearing, he resigned. In his case, date of consideration is the date of inquiry and date of hearing, not on the date of application. In my case, my land was not changed the character on the date of application. In my case, according to the state, vital date is date of application. In his case, date of application is not the vital date. The date of inquiry and date of hearing is the vital date when he resigned. My land has been converted prior to inquiry, whether it is 1 day or 3 days or 5 days material. Kindly take note of once again the report, page 46. What is the report? The district level sub-selection committee shall proceed on the basis of the documents and papers. It says, page 46, kindly turn. Column number N from bottom 5th column. Character of the land, Vastu. There is any further inquiry. This is the document, this is the records placed before the district level sub-selection committee. What is the consideration? My land was Vastu. There are instances when application is being made, shop room is not completed. During the period when the inquiry conducted, shop room can be completed. There is no bar to construct and complete the godown or shop room during the 10-year period of date of making application on the date of inquiry. If it is found on the date of inquiry, everything is all right, so far the construction of godown and shop room is concerned, his candidature should be considered like other candidates. In my case, on the date of application, I am admitting, my lord, there was no change of character. But when the inquiry has been conducted, shop by shopman, godown, bank balance, and other things, it is everything all right. On that sole ground, my candidature cannot be rejected, and they have not also rejected. They have treated me as an eligible candidate. Out of 11, only 3. 7 they have rejected. On the threshold, not being eligible candidate. My last submission would be, my lord, I have relied on 2 judgments. I have bought the books, but it's not required. The one judgment says, if the amendment is beneficiary, then it is retrospective. It is beneficiary to the all candidates, providing marks, even the land is not converted, 1 marks. Second logic, which has been framed by the Honorable Supreme Court, is that if it is clarificatory, then it is also retrospective. There is an omission. You can apply with agricultural land, but at the date of inquiry, it should be, my lord, converted to the either Dukan, Ghor or Vastu. That I have done. This clarification came into picture to give more opportunity to the more candidates to get the best candidate in the selection process. It is a settled principle of law. A selection procedure shall be initiated and concluded to see the most suitable candidate can be appointed or selected, so that the beneficiaries will be the most beneficial. Dealer, distributors, officials are not the only motto, only consideration in the consumers, the beneficiaries. If my shop room is better, if my godown is better, if it is adjacent to the central location, if it is approach road is higher, only on the ground that your application, date of application, it was not converted. Rejection means you are choosing a inferior candidate than that of a better candidate. Because this is only for the consumers. Convenience and convenience. Well, these are my submissions. I am praying for a stay of operation of the order, at least status quo.
Only one thing I would like to clarify. that there are three shortlisted persons according to
Who were interviewed,
been interviewed. If my selection goes, then he may definitely come. It is not that vacancy will come. Vacancy comes only if all the three are eligible.
Yes. Great.
So far the judgment relied by my learned senior friend Mr. Agarwal, civic volunteer is concerned, but this part has not been considered, which I have submitted before Lordship, the notification. This is part in period according to my understanding, because this notification has not been placed before the court, and that has not been taken note of. Your Lordship, kindly go through the judgment.
No, show me the notification of the state Bengal police.
Then it will Lordship, kindly keep it on Monday. I shall keep it on Monday. Nothing will be happening in the meantime.
This is the notification of Calcutta police.
Yes. I shall place before the Bengal police. My learned senior friend Mr. Dutta is correct. There are two rules. PRB
Whatever may be the judgment is very specific regarding the post.
Yes.
Whether
That's the
civic
crux of the
volunteer
matter.
or the home guard are holding post or not. This is the observation of the Honorable Supreme Court.
My lord, kindly come to page 9. The difference, home guard and that has been done by the learned single judge. My specific case is that home guard is the inferior post, not the civic volunteer. There is no rules. Paragraph 9 says, take into account the aforesaid constitutional provision and the scheme of Home Guards Act. Civic Volunteers Act have never been dealt with. Now the learned single judge jumped into and say that this is the same.
This is not the appeal court.
It's below.
The coordinate bench. Sorry.
This is not the appeal court.
So far the Home Guard is concerned and the civic volunteer is concerned, this is a hell and heaven difference.
Very good.
So Lordship, keep it Monday, I shall place the circular. No, Bengal circular fine job.
When you take a circular, my lord, this judgment remains. And that has been.
Whatever be, you want the Monday? Very come on Monday.
Kindly record my lord, the point of maintainability point is open.
Yes.
আজকে কিছুই করছে না যাচ্ছে
না না একটা অর্ডার তো হবে
for the state.
এতক্ষণ ধরে কথা হলো
Please take down.
কথা হলো and more kindly this point has to be taken at the threshold that the petition is premature and that point will be decided at the final hearing.
Final hearing na Monday.
Final hearing.
ওটা অ্যাডমিশন হয়ে গেল।
Preliminary point.
Instant writ petition is preferred.
আপনারা বের করতে হবে না?
For issuance of mandamus upon the respondent authority, so that the present petitioner may be appointed and granted FPS license in terms of vacancy notification dated 16th of May 2024. Full stop. Argument on behalf of the parties heard in part. Let the matter appear in the list on the Monday under the same heading.
That will not cut you.
আমার সঙ্গে থাকবে এটা না এখানে রাখো এমনি রাখো
Monday under the same position.
same position.
In the meantime.
Next.
In the meantime, let us see.
Yes, which for the petitioner?
May it please your lordship.
Yes.
Lordship, I am appearing on behalf of the petitioner. I am the fair price shop owner. I have around 10,000 DRCs tagged with my fair price shop. Lordship, this matter relates to issuance of a vacancy notice in respect of my operational area. Your Lordship is well aware of the 2021 policy guidelines and in and the two orders passed by the Director DDPS, the 2022 and the 2023. Your Lordship, I am challenging this vacancy notice on 3 grounds. Firstly, Your Lordship, the vacancy notice itself has been passed pursuant to the 2022 and the 2023 orders, which were without jurisdiction, and hence the vacancy notice itself should be declared null and void. Secondly, Your Lordship, even otherwise and irrespective of the government of the orders passed by the director, the vacancy notice is contrary to the 2021 policy guidelines itself. And thirdly, your Lordship, there's another aspect to this matter. If Your Lordship may kindly take up page 30.
The 2021 policy guideline, what does it say?
Lordship, 2021 policy guidelines, you'll
What is the minimum number of DRCs?
6,500 to 7,500.
Then you are holding 10,000?
10,000. Your Lordship,
Then
Your Lordship,
you are
if
holding more than that.
No, Your Lordship, this is a vacancy which was created in my operational area.
May I explain very humbly, as what I have understood from the writ petition, what he is his apprehension that since he is having 10,000, we may detag. He,
Correct,
correct. This is what he wants to submit, that we may detag and we may bring it, curtail it. And he says that he is with a clean record. So this is what his contention is now.
Firstly, that, and secondly, Your Lordship, the policy says that a new vacancy can only be created if there is more than 12,000 DRCs tagged. If Your Lordship may kindly see page 33. Page 33, situation 1, in the middle of the page. In case of, has Your Lordship got it?
Yes. In case of overpopulated FPS.
In case of overpopulated FPS, having card population more than 12,000, proposals for new vacancies may be given of appropriate locations of the areas under the service of the existing FPS through bifurcation of the card population. Lordship, my humble submission is, I had only 10,000 DRCs and the new vacancy is being created. And this is dehors the policy because a policy only allows a new FPS vacancy to be created if my FPS DRCs are more than 12,000. This is not the case, Your Lordship.
You see the
situation 2.
Situation 2, you come under that.
Your Lordship, that's with respect to detagging. I am concerned with bifurcation. So I'm not.
Maybe there is detagging of 3,000 or 5,000 cards from your existing 10,000 to 12,000.
Lordship, state may just inform then what is the current situation also, because vacancy notice was dated 7th March and the last date of submission of applications were 45 days.
Lordship has, no, ঠিক আছে, হয়ে গেছে, you have explained. Situation 2, Lordship has seen. Now here what this is completely based on apprehension. What he is apprehension is that since a notification is there, likely every possibility detagging will be there. Nearest FPS may get a card share of the card. In that case, Lordship, there will be, we'll also be rid of that headache. If it be remanded to the authorities, let them take a decision with respect to these grounds.
So what decision? What is the prayer in the writ petition?
Kindly seize the press.
What you want?
Your Lordship, firstly, I want mandamus on the vacancy notice itself, and Your Lordship.
Say he wants.
Yeah, correct. At this stage, I want an interim order restraining the state from taking any action in respect of the vacancy.
You have challenged the Director DDPS order dated.
Yes, Your Lordship.
2022 and 2023.
Correct, Your Lordship.
But 2021, you are saying that it is okay. So they can proceed according to
2021.
Your Lordship, the state may file a report because at this stage I'm not aware of what is the grounds for proceeding with the vacancy. If at all it is the detagging or if it's the bifurcation.
It is just a state policy. It is just a state policy that will be for detagging or anything.
You are holding more than
10,000. Yes.
You are admitting.
But then the state must say whether I fall under situation 1 or situation 2.
Situation 2 is very clear.
Let them take a decision.
Yes.
Let them take a decision.
In this, that is what I'm saying. If situation 2 is there, let them take a decision.
If the state may file a report on this.
No, why report is not required?
Have you placed any representation to the
Let him, your lordship. No, I could not see. I was looking through the writ petition. There was no representation. Let him make a detailed representation explaining what he exactly wants somewhere, because he is what falls from lordship and what I have submitted before your lordship, two situations. He's taking care of situation one, challenging orders 22, 23, but saying that situation one is intact. And situation two is our explanation. So in that case, let the authority take a decision. लेकिन पढ़े नो situation two तक.
Okay, please take down. Petitioner is a FPS dealer.
Lordship, the affidavit of service has been filed.
Affidavit of service filed on the petitioner is taken on record. Petitioner is an FPS dealer. Is an FPS dealer. Catering ration articles. At Gram Panchayat Altapur 2 under block Koron Dighi, having having godown location at Bilaspur under subdivision Islampur district Uttar Dinajpur. Full stop. Petitioner challenge a vacancy notification dated 7th of March 2025 issued by the SCFS Islampur in respect of central location Ibrahimpur ICDS. It is the contention of the petitioner that if anyone was appointed in terms of the said vacancy notification, the business of the petitioner would be hampered. Petitioner has submitted in the writ petition that the DRC ration card population linked with the petitioner FPS is more than 10,000. In the instant writ petition, he had challenged the policy decision of the state issued by Director DDPS dated 11th February 2022 and 28th March 2023, wherein the Director DDPS has fixed the number of DRC population to be retained by existing ration dealer, which is 5,000, full stop. The present petitioner is an apprehension that if the said notifications dated 11th February 2022 and 28th March 2023 was given effect to, the DRC population of the petitioner would be crunched বা reduced করে দাও. Ms. Sonal Sida, Learned Counsel, appearing on behalf of the state authority, submits that the state of West Bengal had issued a policy guideline on 3rd of September 2021, wherein it has been stipulated that in case of population of FPS having card population between 10,000 to 12,000, having card population between 10,000 to 12,000, comma, around 3,000 to 5,000 cards of the existing FPS may be considered for detagging and to be clubbed with the detag overpopulated card of any neighboring FPS for declaration of suitable new vacancy. New vacancy, হয়েছে? Ms. Srina further submits that the decision of the state regarding detagging of FPS, regarding detagging of DRC population of FPS of the petitioner has not been taken yet. So the petitioner may approach to the competent authority for desired relief. Or the learned counsel for the parties peruse the prayer made in the writ petition. It appears that the petitioner has challenged the policy decision of the state passed in the year 2022, passed in 11th of February 2022 as well as 28th of March 2023. The petitioner has not challenged the policy guideline of the state dated 3rd of September 2021. It appears to me that the state has every opportunity to act according to the policy decision of 2021. In that score, no, 21 full stop. It appears that petitioner is an apprehension that his DRC populations may be detagged by fulfilling the new vacancy, new impugned vacancy notification. However, it appears that the entire writ petition was filed under apprehension. No decision of the authority has been challenged in the instant writ petition. On that score, I think it necessary to refer the matter to the concerned subdivisional controller food and supply, Islampur, being respondent number 4, to ventilate the grievances of the petitioner. Under the above observation, the instant writ petition is disposed of, directing the petitioner to approach the respondent number 4 with a detailed representation on such with a detailed representation regarding his grievances. Full stop. The subdivisional controller food and supply Islampur shall dispose of such representation within 6 weeks from the date of making such representation, after giving a reasonable opportunity of being heard to the petitioner. The decision of the authority shall be communicated to the petitioner within 2 weeks thereafter. Full stop. This court has not entered into the merit of this matter. The respondent number 4 shall take independent view without being influenced by any objection of this court. Since no affidavit has been exchanged between the parties, allegation made in the writ petition shall be deemed to have been not admitted. Disposed of.
Obliged, Your Lordship.
No.
And this is the grandson of Mr. Agoral.
That is right. So nice. Young children coming up.
Thank you. Grateful Lordship.
But I am for the petition. Every sense. The usual order I am paying for. So for transfer of customers from petitioner district pair G and H manner same identical at page my lord 34. The circular dated 21st February and the transfer order 15th June 2025. Page 34 and a pair G and H.
Who is appearing for the
Possibly they will not happen.
Oil marketing.
For identical matters, in some cases, oil marketing company.
Have you served?
Yes, they will serve. Hand service is there.
Usually they
Appear, but when equals similar border is passed, I have seen my lord some cases. Because I have talked to both the advocates, they have statement the copy has not been served.
Without
The
their
data
presence,
and the portion
order would be there, I understand, but without their presence,
usual order, my lord. Otherwise, my lord, again they will return. Long back it has been filed, long back it has been served. Because they will not suffer a similar order since your lordship is going to pass. Next day, তো দুবার হয়েছে তোর ঝামেলা। My junior had a talk with Mr. Mukherjee and also Mr. Nag. Both they told that they have not been briefed.
in the order I have noted their submission in detail.
Your lordship, relying on this order, only one half full line order may be passed, following the order of this, because in vacancy matters, your lordship also being passed following the order. So, since the similar order is before your lordship, my lord, in terms of that order, pair portion may be given. Identical issue, identical order. Since in number of cases, order has been passed, relying on the same, order may be passed. And no appeal has been prepared till now. Order may be shortened.
Okay.
Order. তারপর কাজ হবে স্যার সে আজকে পুরোটা নেবে আজকে তো সারাদিন নেবে বুধবার
There is also BPCL.
My lord. And communication is there.
Okay, please take down. Affidavit of service filed on behalf of the petitioner be taken on record. Full stop. Despite service, none appears on behalf of Union of India or Bharat Petroleum Corporation Limited. Full stop. Next para. Petitioner is a distributor of liquefied petroleum gas, in short LPG, bracket close, who is distributing cylinders of respondent oil marketing company to the customers. Full stop. Petitioner challenges the circular dated 21st February 2025 on marketing, restructuring and customer transfer policy issued by three oil marketing companies, namely Indian Oil Corporation Limited, within bracket in short IOCL, Bharat Petroleum Corporation Limited, in short BPCL, and Hindustan Petroleum Corporation Limited, in short HPCL. It appears that challenging the similar notification several writ petitions were placed before this court, which was heard in presence of the oil marketing companies. In each of the one of them, order of one of them, that is Gautam Basu versus Union of India, within bracket WPA 15924 of 2025 bracket close, is placed before this court. I am also informed that other three similar writ petitions were also filed by the distributors against the oil marketing company. In all the cases, this court has passed the interim order in terms of prayer G and H of the writ petition.
Page 34. Interim order, and thereby state the operation of circular stroke policy decision dated 21/2/2025, issued by three leading oil marketing companies, namely IOCL, BPCL, and HPCL. As this court has taken the decision already in respect of the issue involved herein, thus I think it necessary to pass the similar interim order and directions to that of the other writ petitions. Accordingly, the oil marketing companies stroke respondent authority is a leave to file affidavit in opposition against the writ petition within 4 weeks from date. Reply, if any, by the petitioner within 2 weeks thereafter. Next. Further, considering the entire facts and circumstances, on principle of issuance of interim order, it appears that prima facie balance and convenience and inconvenience is tilting in favor of the petitioners, as they are admittedly losing their customers. Thus, this court feels appropriate to pass an interim order. Hence, there shall be an interim order in terms of prayer G and H of the writ petition for a period of 8 weeks from date. For 8 weeks will be the puja vacation. But yesterday, Your Lordship passed an order on 12 weeks.
For the 12 weeks.
I'm getting ready.
Affidavit of service.
Affidavit service may be kept on record.
Yes.
ডাকছে কিনা দেখ আমি কিছু করিনি
Now we are for the petition. Mr. Basu is supposed to, Mr. Kallol Basu is supposed to complete his argument today.
On the earlier dear lordship, let me recapitulate a portion of the arguments that was made on behalf of the ADDA. Lordship, the bone of contention of the petitioner is that there was a lease deed based on which he was supposed to make constructions in the subject premises within 3 years. In the meantime, he had applied that he will be making a construction of a multi-storied building and create a group housing for that. We had raised certain conditions subject to which the development will be granted. That was in the year 2017. There was initially we took a point of maintainability that in the act itself there is a provision that if anybody is anyhow aggrieved by any conditions, precondition that is imposed for grant of a development permission, appeal can be preferred under section 47.
Yes.
And it's in the year 2017 that these conditions were imposed. After the 90 days, 3 months elapsed, no appeal was preferred, and sometimes in 2021, a representation was made for reconsideration, and the same thing was reiterated in 2021 itself, and the writ petition was filed. In the meantime, there were certain communications between the parties in which he never challenged the power and the authority of ADDA to impose any condition.
But they want the
Quantum.
amount to be quantum.
So our contention was that we cited few judgments that when there is a prescribed period of limitation and that expires, after that writ petition is not maintainable in view of the expiry of limitation. And the second judgment that we cited is in respect of whether it was an order in 2017 itself. Thereafter, the limitation passed and a representation was made and a fresh order was passed citing the same grounds as in the earlier order. And the Honorable Supreme Court in this regard has held that if a claim is a stale claim, a fresh representation and a same order being passed will not stretch the period of limitation. And one stale claim, a representation is disposed of will not revive the earlier claim. And the Lordship, now I'm led by Mr. Kallol Basu, perhaps he appearing virtually.
Where is Mr. Basu? No, you have argued a lot. So today you are supposed to cite some judgments like that.
Lordship, let me continue. I think he will join.
Thank you.
Kindly takes up the demand that's at page number 59. It was the initial demand in the year 2017. Kindly takes up page number 58 for once. It is the application. In the second paragraph, he says that we have invested huge amount for the said plot. Many of our relatives as well as friends are pursuing us for the residential house at Durgapur. As the residential land are limited in the hand of ADDA, so they are not fulfilling the demands of the maximum who are applying to ADDA for their own residential land. So ADDA is planning to distribute the plots of land in the form of cooperative housing society by which in the limited land maximum residential house may be constructed and by which they may please most of the applicants. Considering the above, we have decided to construct group housing cooperative society As per views of our architecture, we may construct 32 number of flats on the said 18.13 katha of land, and we provide 32 families to their own residential flat, and pressure of ADDA for demanding residential house may be partly decreased. I pause here for a moment. The lease deed initially was granted to an individual for his own use, for building a residential house for his own purpose. Now the same person comes up with a proposal after elapse of certain period of time, when he has not taken up any construction, and he says that there is an increased demand in the locality for housing properties and flats and all, and he wants to cater to the demand. Here a basic point of economics comes into play: demand and supply, and interplay of demand and supply gives rise to profit, which is essentially a commercial issue. Based on this, and also he wants to build a residential flats 32 numbers, and with an enclosure of a project report that we have disclosed in the affidavit in opposition.
Now, whether ADDA has authority to allow any person to convert.
Lordship, we have authority.
You have the authority.
Authority to convert.
Yes. So whether residential property can be converted to group housing cooperative.
Lordship.
So what is the conversion charge?
Lordship, when residential is converted to group housing, I say residential is being converted to a commercial purpose. Because say, if a person who is building a property.
No, if you say that this residential purpose intend to convert to a commercial use, whether their ADDA is authorized to convert same.
Lordship, there is a notification that the petitioner has disclosed. It's at page number 65.
Page number 65.
65, Lordship. It says in exercise of it's dated Monday, November 28, 2011.
Yes.
Lordship, this is a notification which provides for conversion from residential to commercial. I'll draw your Lordship attention to page number 67.
Yes.
P says rates proposed for change of use. At the top. On government land leased out by ADDA is the point number 1. It says this is a government land leased out by ADDA and he's the lessee. Now first serial number 1, it says residential to commercial differential land premium.
Previous rate as per notification, differential land premium.
Lordship. And revised rate is also difference of land premium. So this is the notification from which we draw the power that we can impose difference of land premium. Coupled with this, if I say for a moment that I say that the contention of the petition is correct, that there is no conversion, for argument's sake, there is no conversion. It is only a residential to residential, though I'm not admitting it, but for argument's sake, it's only residential purpose. So I cannot impose any conversion charges. I can fall back on the lease deed itself. Mr. Basu is here.
Yes, Mr. Basu.
My lord, sorry, I tender my apology, my lord. Here, my lord, Mr. Chatterjee, let him complete his argument. My lord, I will only, then I will, my lord, permit me to, my lord, wait 5 minutes time. Let Mr. Chatterjee, my junior, may what he intend to say, my lord, I just entered. I'm sorry. If he wants to say that the lease deed, which I also last day relied upon. First of all, my lord, my submission was that the whatever demand I made, that demand was accepted. There was no
only
clamor.
dispute is quantum.
So today, they accepted their known personal right and relinquished it. It is a kind of a waiver. And waiver, my lord, and the law had given them right. Section 47 stares at them. Appeal has to be filed. If they could have come within that period before the High Court, see this is not Supreme Court judgment was relied upon. And lease deed, parties are bound by their contract. The lease deed I had read for your lordship's consideration. Parties cannot ask the REIT court to rewrite the contract after the limitation period is over. It's a government land. Government has also a right. Your lordship knows, Miller, under Article 299 of the Constitution of India and 229, Chief Justice also, Miller, the 229, it's a contract, and the executability of the contract, my lord, that is not for the court's domain. Court can only say that whether there is an element of arbitrariness. By way of this, from a single person to 32 flat, and prayer for broadening the road and other issues, Miller, which indicates that there is a commercial venture. If the nature of the transaction is changed by reason of the substance of the application, by the conduct, then, Miller, the state has also equal right, because it is an authority under Article 12. It works for the public authority, Miller, public, and it's a welfare state. The state can, not a rank profiteering, but state can also make a demand within the periphery of its circular and law. In the instant case, all this could have been a brilliant argument, Miller, had the petitioner approached this honorable court, Miller, by taking recourse to the appellate authority or by way of a writ application within the time, that means within the appeal period. Nothing has been done. And no delay has been explained. And why such delay has been, could not be attributable to them. On this score, Miller, I would request that it is a question of equity, justice, and good conscience. Miller, delay defeats equity. It applies also in respect of an injunction application as well as also, Miller, writ petition. Today, Miller, the writ petitioner is not before your lordship for execution of an element of a public interest. It is absolutely a prayer made by the petitioner when they crossed their limitation, when they failed to negotiate, and then came to the writ court. Miller, what they could not do directly, now they are coming, now trying to take shelter, Miller, under the 226 on a misconception that the writ court, although has an ample power, but at the end of the day, it is a discretionary relief, and discretion must be informed by reason. That is my respectful submission. And if my learned junior, Miller, wants to add, Miller, what he could not complete, I'm sorry I interfered. If your lordship permits my junior for 5 minutes.
Yes.
Actually, I was saying that even for argument's sake, if it is taken that no right to impose conversion charge was ever there. Even so, if I fall back upon the lease deed, lordship kindly takes up the lease deed. It's at page now. The relevant portion is at page number 24 and 25. 24 আর 25
Yes.
This is the lease between, it's dated 21st day of May 2012 between the governor of West Bengal, and from which the petitioner is drawing his right title and interest. In this lease deed at page number 24, lordship kindly takes up the second last paragraph.
Yes.
It says, it was kindly marks it, it's in the from the year 2012. Should the lessee fail and neglect to erect and complete construction of building as aforesaid within 3 years from the date of this present, the lesser government shall have the right and shall be entitled to determine this presence thereafter to re-enter in the demised layout plot or a portion thereof in the name of the whole and resume possession thereof. So admittedly, lease granted in 2012, he applies for making construction in the year 2017. So there is a default on the part of the lessee himself, which is clear from this clause. And then in page number 25, lordship,
yes,
the next page kindly takes up the Roman 10.
Yes.
It begins with not to assign, underlet, or part with the possession of the demise layout plot and buildings erected or to be erected thereon, on any part thereof, without first obtaining consent of the lessor in writing, and in any event not to any person who is not qualified to be an allottee of such plot of land under the Land Acquisition and Development Rules of West Bengal, the government lessor shall have the right to impose such condition as it may think fit, including charging difference of land premium in the event it decides to grant consent to the lessee for assigning the leasehold interest in the demised layout plot to any other person. Now, why I am relying on this? It's because initially the lease was in the favor of an individual. If there is a change from an individual to a cooperative society, this in itself is an assignment and a transfer, and a fresh lease deed has to be entered into between the lessor and the cooperative society, keeping this lessee as a third party into it. So, for granting such a permission to transfer and assign, I can impose difference of land premium. From the conversion charges, what I am imposed, it's also a difference of land premium. So either way around, whether I draw my power from the lease deed itself or from the notification, then the memorandum, we can impose difference of land premium. And the second point, Lordship, is that kindly takes up on the same page, the Roman 12. This in continuation to the earlier clause.
Yes.
Not to transfer or dispose of leasehold interest of the lessee in the layout plot, save and except upon obtaining prior permission of the lessor in writing, and subject to payment of requisite transfer fees, as may be fixed by the authority and may be amended from time to time by the lessor, along with difference of land premium and other charges, if any, and after ground floor roof construction is completed. So this is not relevant. So here also I have been provided with the right to impose transfer fee and difference of land premium.
No, you are not imposing any transfer fee like that. You are imposing only the conversion charges.
Conversion charges, but conversion charges I'm imposing under that memorandum that I've just relied upon. It says from residential to commercial, if I have to impose, I have to impose difference of land premium.
Yes.
So there the computation of the amount is of difference of land premium. Here also it's difference of land premium. So the quantum remains the same. Either way, whether I rely on the lease deed or from that order, it's either way it's the difference of land premium and also transfer fees.
Okay.
So the quantum does not change.
That's all.
And in this respect, Lordship, I'll rely on one judgment. Every time we are used to hear that the petitioner says that he has suffered from Article 14 violation because somebody has been favored. Here, for the first time, the Honorable Supreme Court comes and says, if a development authority favors a erring lessee, that is also violation of Article 14. Say he has been not following the lease deed, he has not made construction. There are, even after that, if the court directs to consider it, that's also violation of Article 14. Lordship kindly takes up paragraph 17 and 18. It's reported in AIR 2023, Supreme Court 2090. AIR 2023, Supreme Court 2090. In the ordinary course of business, as the respondent has failed to deposit in terms of the tender document the last installment by such and such, the auction was supposed to be cancelled and earnest money deserved to be forfeited. We find no reasonable justification in the present facts and circumstances as to what would be the reason for undue indulgence being shown to the respondent while extending him the benefit to deposit the installment by 25th such and such. We have our strong reservation, and such exercise of power by the authority, in our view, is a clear abuse of discretion, which is not only violative of Article 14 of the Constitution, but also smacks of an undue favor, which is always to be avoided. And whenever there is such a business commercial transaction, it is always to be examined on the commercial principles where equity has no role to play. Be that as it may, as much water has flown in Ganges, we would not like to stretch it any further. Next paragraph. However, the fact is that the parties sitting across the table got the lease deed executed for such square meters without demur on such and such, and the transaction stood concluded after execution of lease deed, which was initiated pursuant to a tender floated by the appellant. And since the lease deed was to be compulsory registered under Section 17 of the Registration Act, it was nowhere open to be altered or amended even by the High Court in the exercise of its jurisdiction under Article 206 of the Constitution of India. See, why I rely on that? It's for two reasons. Here, admittedly, he has not taken up any construction and he is acting against the terms of the lease deed. 2012, the lease deed was issued, granted. He applies in 2017. Lease deed provides for 3 years. Now, even after that, I have provided him an opportunity to make such construction. That is also he is challenging. So now today it's 2025. Original grant was in 2012. Already 13 years have passed. Now, even after this, if I indulge and provide him with more time, this will be violation of Article 14 because this is a public land. Other persons are also entitled to it and is liable to be auctioned. And there is a clear mandate of the government of West Bengal in this regard that those lands which are remaining unutilized has to be resumed. Lordship, for this regard, I am relying on this paragraph 17. And the next paragraph, it says that it's a concluded contract. Lordship, I have shown the terms and conditions where I can impose difference of land premium. And I have acted as per the contract, so this cannot be interfered under Article 226 of the Constitution of India. Lordship.
Okay. For the state. A DDA is doing the matter, he is the respondent authority. Answering authority is the auditor.
Okay.
Okay.
I am deeply obliged for your lordship's kind hearing, patience hearing.
Thank you. Reply.
Mr. Mojumdar is leading us in this matter, my lord. So would your lordship not fix, will not take more than 15-20 minutes, but
that is the difficulty.
Tomorrow, any day,
no.
As per your lordship's convenience.
সেপ্টেম্বরে দেখো 8 তারিখে 9 তারিখে 12:30 9th of September 12:30.
9th September 12:30.
Argument on behalf of ADDA as well as the state of West Bengal concluded. Let the matter appear in the list for argument on behalf of the petitioner in reply on 9th of September 2025 at 12:30. Okay.
I am for the petitioner, my lord. I am seeking for a short passage.
Next.
21 Mala, I am for the petitioner. This is my affidavit of service and my lord, the notice of upgradation, my lord, also my lord, the serve upon the state respondents as well as.
Who is for the state?
My lord, Mr. Nilotpal Chatterjee along with my lord, the
Mr. Nilotpal Chatterjee. Yes, what is the matter?
My lord, matter very short, my lord. There was a vacancy declaration. My lord, kindly have a look. My lord, page 18 is the vacancy notification.
Yes.
My lord, it's related to my lord, in the area, my lord, the Panchayat area. My lord, the last line, the notification dated, though it is dated 31st May 24, actually it was published on 30th July 2024. The bottom portion in the right hand side, seal and the signature of the authority. In the bottom, column number 6, last date of submission, the application.
45 days after advertisement.
Within 45 days. The 30th July, since the August, September, within September, 15 July, August and 15 September, they have to applied for the post. Requirement next page, eligibility criteria. The page 19 is the eligibility criteria. What would be the requirement that has been specifically mentioned. And the page 20, the serial number 10, the applicant must submit the following documents. Which are the documents required for submission of the along with the application? That was the specifically mentioned here. In terms of that that notification, the go down, where the go down is situated, the land should be in 3 characters. There, the kindly have a look. The Roman 6 and the B, Roman 6B, the document showing character of land, got it, the page 20, Roman 6 and B, A, capital A and B.
Dukan commercial vastu.
Yes, is the 2 candidates were the call for interview. After shortlisting, the 2 appeared. After the interview, the petitioner came to know the private respondent, so who made application, his land was converted after the after the cut-off date. Since I have already annexed his documents, that his land was in character was Danga. That was that since his land was Danga, he was not eligible for making the application. If he is not eligible for making the application, his candidature ought not to be considered in terms of this notification. This is only very short point. I have annexed the his R1 then
it may be converted.
But I have also annexed his notification for hearing of conversion his notification page 47. 23rd the date was fixed issued the notification for conversion hearing. Page 47 the got it. It's a notification issued for by the concerned BLRO for hearing on the application for conversion. And 30th September was the date for the fixed for hearing. From the notification itself, it says on before 30th September, the land was the Daha. There was no scope for conversion. Got it. This is the only point. Whether since he was not eligible and he was the documents of land was not in the commercial vastu or dukan, he was not eligible. His application was defective. How his candidature is considered for consideration. This is the only point. That
Page 47 is which is this?
He's
plot number 2066.
Yes, the private respondent the application the plot in which private
respondent name
it's one of the his father names the private respondent, it's a land of his father.
What is the name of his father?
The private respondent who has been so-called from I have came to know private respondent has been selected. His land belongs to his father. He made application for conversion. my lord, this is
What is the name of the father of the private estate? We have not mentioned it.
yes, yes, my lord, at that point of time, my lord, that was not my lord, the disclosure. That's why, my lord,
you must have mentioned the name of the private respondent and his father.
Well, private respondents have name has been mentioned, my lord.
What is the name of his father?
My lord,
the name you are showing a land in the standing in the name of one Haidar Ali.
Yes, yes, my lord. Sheikh Haidar
Who is Haidar Ali?
Late Mala government, state or the private respondent came so Mala the whether Mala this land Mala they whether the land Mala the private respondent applied for this land or not, Mala. That can say
No,
Mala
you cannot say like that. You must have a specific case before this court.
I have specifically stated, my lord, the name has not been mentioned, my lord.
Then why not mention the name?
That I have applied earlier, my lord. Then that I have learned that the go down.
Land of respondent number 9 was recorded as Danga.
In representation, my lord, the page my lord 51, my lord, the 50 my lord is my representation. My lord, there, my lord, I have also my lord mentioned
that you were the eligible person.
Yes, my lord, only 2 persons were called for my lord, interview. My lord, if my lord, the candidature of my lord, the private respondent is goes, my lord, then I would be the only person, my lord,
Show me some document that the name of Manjur Hossain, there are some land standing.
Sheikh Manjur Hossain, my lord, it is also learned that I have applied for
classification of Danga.
Manjur Hossain. And I have been learned that the proposed land of Sopcom Godown site of Sheikh Manjur Hossain is recorded as Danga, but without desiring as per law, the time is given to Sheikh Manjur Hossain.
So where is the land standing in the name of Manjur Hossain as Danga? Show me something.
So far my instruction, this land, which has annexed in the.
I know your instruction is, but show me something. Who is Haidar Ali? Why you place the Haidar Ali's documents?
Haidar Ali is the father of
No, you have not mentioned it that Haidar is the father. Never mentioned in any of the anywhere in the writ petition or in the address respondent on 9 say see. You have not mentioned the name of his father.
Cause title, that has been.
Yes, you see the cause title.
Yes, that has been the missed, that is
then you miss the name of the father in the cause title.
That is the mistake on the part of my mistake, my lord. That was the that may be corrected, my lord, with the leave of my lord,
No, I want the
yes,
that's why I want to know where is the land standing in the name of Manjur, as you assess the objection. You have never stated in the writ petition that the land standing in the name of the father of the respondent number 9. You have never stated that.
Yes, that must be said, my lord.
No. All land standing in the name of respondent 9, you are saying in the writ petition. Everywhere. File affairs or file a supplementary.
Supplementary, leave may be granted.
Yes. Leave is granted to the petitioner to file a supplementary affidavit in connection with the writ petition. Leave is granted to the petitioner to file a supplementary affidavit in connection with the writ petition. Let the matter appear in the list under the same heading on
next week,
10th of September 2020.
Before that, next week, any day, next week,
3rd September.
3rd September. Yes. Yes.
Next.
I'm for the petition, my lord. Affidavit of service. My lord, In this matter, my lord,
My lord, may I interrupt, my lord? 21, my lord, state is appearing, my lord, the
Give me your name. I have fixed the matter, giving liberty to the petitioner to file a supplementary. Give me your names. Yes.
my lord. In this matter, my lord, the petitioner has been granted appointment on compassionate ground, my lord, pursuant to the order of the Honorable Court, my lord. And my lord, offer letter has been given. My lord, kindly come, my lord, on 21st April 2025, my lord, by two memos, my lord, one 298 and 299, my lord, for FPS dealership and kerosene oil dealership. My lord, offer letters has been given, my lord. Kindly come to page 39, page 38 and 39, annexes P4 and P5.
Yes.
My lord, the petitioner has completed all the formalities, my lord, deposited the license fees, requisite security deposits, and the documents have already been forwarded to the concerned office, my lord, within time, my lord. And my lord, thereafter, my lord, the petitioner has come to know, my lord, in second week of July, my lord, that a vacancy notification has been declared in the self-same location, my lord, where, my lord, the petitioner's mother-in-law used to function, my lord. My lord,
Are you catering business now?
no, my lord, I have not been granted the license, my lord. Offer letters have been issued, but my lord, license is still pending. And surprisingly, my lord, a vacancy notification has been issued on the self-same location.
Self-same location?
Self-same location.
Where is the
Kindly come,
vacancy?
my lord, kindly come to page 64, my lord, the location where my mother-in-law used to cater, my lord. That is the license, my lord. I have annexed the licenses, my lord.
Who is for the state?
Miss Sonal Sinha is appearing, Your Lordship. Kindly makes it not today. She's on his legs in other court, I guess, presume.
And offer letters have
Where
been
if the
issued
junior
on
is-
21st April 25. And since then, my lord, I have not been granted the license, my lord.
Actually, the junior is also not here, and Miss Sinha is on her legs, Your Lordship. Kindly makes it not today, Your Lordship. I do not have the instruction in this.
Tomorrow, my lord. Since
Tomorrow, group
tomorrow,
one matters.
my lord, at 10:30, my lord, it will take, my lord,
No, no, no.
hardly 10 minutes, my
No.
lord, 5 minutes.
Monday. Monday order heading to mention first. Let the matter appear in the list on 25th of August 2025.
And at the top, my lord.
এই শোন সোমবার কি দেব প্রথমে নিউ মোশন ম্যাটার নিউ মোশন সোমবার নিচ্ছি তো নিউ মোশন নেবে ফার্স্ট নিউ মোশন আছে ফার্স্ট নিউ মোশন নেবে তার আগে এটা দিয়ে দেবে
Today, my lord, the date was fixed by your lordship, my lord.
যেহেতু এটা পাঠ ওকে মানডে ইট উড বি অ্যাপিয়ার অন টপ
At 10:30, my lord. Kindly, my lord.
ইট উড অ্যাপিয়ার অন টপ মানডে
At top. I'm great.
এটা কি বললাম বল let the matter appear in the list on 25th of August 2025 on top. Okay.
I'm
Grateful, Your Lordship. Usual procedure.
Usually on Monday I will take up the new motion matters. Okay.
This is a new motion.
This is
There will be new motion matters.
New motion top. Affidavit of service, my lord.
New motion matter is separate heading is there.
Yes, sir.
So these are appearing under mention matters. I have left only 3 or 4 mention matters.
My lordship,
Your Lordship, I do not have.
2013 controller, your lordship, seven January past 2000 controller, lordship, not to proceed.
Admin controller.
Report has to be filed, Your Lordship. It has to be taken.
Similar to the
What?
2013 controller, kindly your lordship, several order passed.
I know. That is the division bench order one.
Yes, Your Lordship. Reports have to be filed, Your Lordship. It cannot be disposed
But
of.
how you appear now? Division bench is pending, going to dispose of this matter. I am not allowing any person to appear before this court on the strength of the same order.
Your Lordship, we'll hear it out on Monday.
2022 vacancy.
2030 or 25, 24.
24 vacancy under 2013 control order. How?
Your Lordship, I have to check, Your Lordship. Your Lordship may take
How?
it up on
On
Monday.
the in
Hear
the year
it out.
2024, there are all new vacancies.
No. There is
15 May 2024. Before 1st August.
Your Lordship will take it up on Monday. Your Lordship,
No, I will take
it
up on top on Tuesday. Tuesday I will take up this matter. Okay, Tuesday I will take up.
Great.